This is a lecture for my professional responsibility class about attorney work product protection. Attorney work product protection. And I want to begin with an illustration, an old illustration from the restatement to highlight both the elements of work product doctrine and some of the differences from attorney-client privilege. A lawyer for an employer, who's a defendant, writes to a physician, setting out circumstances of an employee's death and asking for the physician's opinion as to the cause. The letter explains that the lawyer is preparing for a possible claim by the employee's executor for workers' compensation benefits. The lawyer's letter is protected work product, but it's not covered by attorney-client privilege. Why? Because it's not a communication between a lawyer and a client, or a client and a lawyer. It's a third party, a doctor that a lawyer is writing to, trying to get some information or get some ideas or an opinion. And so therefore privilege wouldn't apply, but work product would. Keep in mind that sometimes both will apply to the same document or item. So now let's go to our definition. Work product is tangible material or its intangible equivalent, other than underlying facts, prepared by a lawyer for litigation. The litigation can be then in progress, or it could be prepared in reasonable anticipation of future litigation. There's two types of work product, what we call opinion work product, which consists of the opinions or mental impressions of a lawyer. All other work product is ordinary work product. So you might think about the physician's letter. If the physician writes back to the lawyer with his opinion about the cause of death, that wouldn't be the lawyer's opinion work product, but it would go in the file and be regular work product. Normally, work product is immune from discovery in litigation or other compelled disclosure when the immunity is invoked. You have to invoke it. Now, an important thing to know about work product doctrine is the need and hardship exception. This is as important to work product as waiver is to attorney-client privilege. There's no protection if the other party has a substantial need for the material in order to prepare for trial, i.e. it's irrelevant or prejudicial. And two, is unable without undue hardship to obtain the substantial equivalent of the material by other means. Need and hardship, of course, is not an exception to attorney-client privilege. And so this is a very important distinction, and it's part of the weakness of work product protection, is that this is actually pretty easy to show for the other party. On the other hand, need and hardship does not matter if other privileges apply. Remember, sometimes a document could be work product and be protected by attorney-client privilege if it's a document about a conversation or the document itself was a communication between the lawyer and the client, or other privileges like the privilege against self-incrimination. Now, which is broader? I highlight this to illustrate for my students some of the confusion in the courts, the federal courts, about this. And by the way, I got this example from the Privilege Points blog by an attorney from McGuire Woods law firm. It's an excellent resource. I highly recommend it to my students. So these are from 2018. On August 1st, a federal court in Ohio put out an opinion that says work product doctrine is broader than the attorney-client privilege. 1 week later, on August 8th, a federal court in Texas said that work product doctrine is narrower than attorney-client privilege. And 2 days later, on August 10th, a federal court in Florida said work product doctrine is broader than attorney-client privilege. So which is it? Well, the answer is both. Work product doctrine is both broader and narrower than attorney-client privilege, and this is a nice way to illustrate the elements of the rule by comparing and contrasting it with a similar rule, which is privilege. So work product is broader because anyone, not just lawyers and clients, can create protected work product if motivated by anticipated litigation. Remember our example of the physician who might write back to the lawyer in the previous example. Two, Work product includes more items than attorney-client privilege: documents, accident scene pictures, translations, collections of newspaper articles, and so on. And third, work product doctrine is more robust than privilege, because even though there are some cases you can find about work product being waived, protection being waived, we really don't have waiver in the same sense that we do with privilege. So disclosing work product to non-adverse third parties normally does not waive the protection. On the other hand, there's senses in which work product is narrower than attorney-client privilege because it applies only in anticipation of litigation. And remember that attorney-client privilege applies to all kinds of legal work, to transactional work, to someone coming in and just saying, I have a legal question, I need advice, or something like that, and tax law advice and so forth. And here, work product only applies to things that are anticipating litigation. Also, work product is easily overcome if the adversary establishes a substantial need for the withheld work product and an inability to obtain the equivalent evidence without undue hardship. So let's define what's undue hardship here. And the restatement says substantially equivalent material is not available, or if available, only through cost and effort, substantially disproportionate to the amount at stake in the litigation and the value of the information to the inquiring party. Obviously, it's going to be easier to show hardship near the end of pretrial discovery. Right, so you will have a stronger claim that there's no other way for us to get this information. We've tried everything. If you've really gone through all of discovery up till now, and now at the end, near the end of discovery, you're asserting this. What are our common situations? The most common is prior statements by a witness who's now unavailable. The witness has passed away or has left the jurisdiction and we can't find them, or something like that. I'm going to give another example from the restatement. Your client calls you and they've been in a traffic accident and they were injured and they want you to represent them in an anticipated claim. So you as a lawyer or somebody from your law office goes to the intersection the next day and takes a bunch of photographs from every angle and for the file. At some point, months or even a year later, the litigation begins. A lawsuit is filed and so forth. And then a few months after that, we're really have discovery underway. And the other opposing counsel decides that it would be a good idea for them to go take pictures of the intersection. And the problem is, in the meantime, suppose the intersection has completely changed. The town or city did construction and added a turn lane, put in a stop light or a turn signal where there was only a stop sign before, cut down a whole bunch of trees to put in a shopping plaza, something like that. And so the lawyer is the only one with pictures that we know of, let's say from the week of the accident, classic need and hardship, and obviously relevant to litigation about a traffic accident that happened in that intersection. What do we mean when we say in anticipation of litigation? Because if you're a litigator in theory, or sometimes just a law student, you could say that everything we document could be relevant for litigation. That's why we put contracts in writing and so forth. Well, not so fast. So the requirement that work product doctrine only protects materials prepared in anticipation of litigation is actually codified in the Federal Rules of Civil Procedure, 26b3. The litigation does not have to be imminent. Work product applies as long as the primary motivating purpose behind the creation of the document was to aid in possible future litigation. It has to be the primary motivating purpose. And so the fact that you committed a contract to writing, even though that would be useful for future litigation, if you're not anticipating litigation, you're actually anticipating both parties being happy with the contract, then that litigation was not the primary purpose of the creation of the document, so work product would not apply. Also, it does not cover materials assembled in the ordinary course of business. So think about like business ledgers, accounts receivable, and payable receipts from vendors and so forth, or materials created pursuant to public requirements. You should think tax returns or reports to licensing agencies and so forth, or that you would create regardless of any anticipated litigation. And I'm going to give another example here. Think about the employee manual at a workplace, right? That is there for them to use day to day. Of course, internal employee manuals, they're often drafted or at least vetted by a lawyer. The same if I work for a school, we have a faculty manual and a student manual. And again, lawyers are involved in drafting and finalizing these. They do become relevant in litigation, but that's not their primary purpose. We were going to have it anyways to guide the day-to-day operations of the organization. And so that would not be work product, even though a lawyer may have drafted it. So remember that the anticipation of litigation has to be reasonable, right? And so somebody could be just paranoid, right? So it has to be objectively and subjectively reasonable. And here's 3 ways to trigger that. First, let's say there's an outside event certain to generate litigation, right? The party that you just contracted with filed bankruptcy, or there was an accident and a lot of people were injured. Everybody says, wow, there's going to be lawsuits from that. The adversary's explicit threat of a lawsuit. So somebody says, I'm going to sue you, or I'll see you in court, or sends a demand letter. Even though you're not sure they'll ever follow through on that, you start collecting documents or documenting things and so forth just in case. And so now it's reasonably in anticipation of litigation. Less likely, it's not that rare, but I say rare here, the party's own internal actions. In other words, maybe your client is preparing to bring a novel claim. They want to try suing for something that nobody has thought of before. So, and maybe they haven't made a final decision on whether to follow through with it, but they're starting to put together evidence and write memos and have meetings and document some things in case they bring this type of novel lawsuit. What do we mean by materials? We've already talked about this a little bit. Tangible materials include documents and photographs, as we said before, diagrams, sketches, questionnaires and surveys. You might remember the Upjohn case from attorney-client privilege, where the lawyer for Upjohn sent a survey to a bunch of employees to figure out how widespread a certain illegal practice was. Financial analyses, handwritten notes, and digital material. If you can see the image I have kind of in the background of this slide, it's 2 people with a flip chart, drawing on a flip chart in one of those group brainstorming sessions that would totally be covered under work product if it was done in anticipation of litigation. Intangible work product is the equivalent work product, but it's in unwritten, oral, or remembered form. So it could be just a conversation that you had that you recount. It could all be in the lawyer's memory. And an example would be a discovery request for a lawyer's recollections derived from oral conversations with witnesses. Compilations and summaries. Compilations or summaries of non-work product materials can be work products. So for example, a lawyer writes a memorandum analyzing publicly available information. That's work product. Cases, you write a memo about the cases or the relevant statutes or something like that. That's work product. Selections and arrangements of documents not otherwise protected, if it's in trial prep, can reflect the mental impressions and legal opinions. So if you're one of these people who likes, when you do legal research and you find a bunch of cases, you like to print out a printed paper copy of all the cases you're going to use and mark them up and keep them in folders or binders or something like that. Your collection is work product, even though you didn't write the cases. A lawyer's index of a client's pre-existing and discoverable business files is work product if prepared in anticipation of litigation. Now, you may remember from our lectures on attorney-client privilege that pre-existing business records from your client, their business ledgers, are not protected by privilege nor work product, right? But let's say the client gives you their last 5 years of business records because litigation is pending, and you go through them and you create an index for yourself by date and topic or what in order of importance or something like that. Your index would be protected work product. Underlying facts are not protected, and this is something that work product shares with attorney-client privilege. And the distinction is often unclear, partly because work product is so broad and covers lawyers' memories. So it does not apply merely because the underlying fact was discovered through a lawyer's effort and is recorded only in otherwise protected work product. So for example, the lawyer's file memorandum. And so let's say that your client is in an accident, and as part of your investigation, you go door to door in that neighborhood, seeing if anybody saw anything. The names of the people you talked to, those are underlying facts. That's not work product. You didn't write their names and come up with their names. And so, and also, even whether a witness recounts a particular version of events. So whether the witness says they saw it or they weren't there that day and they actually, you talked to someone and they didn't really witness it, or they don't remember, that's not protected work product. Even if the witness is saying, for example, a traffic light was red or green, if the other party requests this, the simple kind of thumbs up or thumbs down, like whose side was this witness on? Are they corroborating your client's version? Not protected work product. On the other hand, interrogatories seeking verbatim contents of the witness's unrecorded statement would be protected. I mentioned before, you have to invoke work product protection for it to apply, and so the party invoking work product has to object, and if the other side says, I don't think it's protected, then you're going to have to demonstrate each element. You're going to have to show that this was something that was prepared in anticipation of litigation. If the other party is going to assert need and hardship, or some sort of attenuated waiver claim, but you should forget about that. Need and hardship, they're going to have to demonstrate need and demonstrate hardship. Okay, let's review our comparison and contrast with attorney-client privilege. Attorney-client privilege protects communications regarding all kinds of legal services, including transactional work. In contrast, work product applies only if prepared in anticipation of litigation. Attorney-client privilege applies only to communications between a client and a lawyer and their direct agents. In contrast, work product includes many other kinds of materials, even when obtained from sources other than the client. Next, and we're near the end here, privilege does not have the same need and hardship exception as work product doctrine. And so in some ways, if you can assert attorney-client privilege, it's going to be more robust in that sense. On the other hand, work product doctrine can survive contemporaneous or later disclosure most of the time that would waive attorney-client privilege. So for example, disclosures to the party's consultants, auditors, public relations firms, and so on. My students may remember from an earlier lecture an example from the restatement about a client who brings their stockbroker to a meeting with the lawyer, and how the presence of the third party, the stockbroker, means that attorney-client privilege won't apply. But work product would still apply to documents from the meeting, to notes from the meeting, or a memo or a diagram that the stockbroker drew on the napkin or something like that, that could, if it was in anticipation of litigation, could still be protected. You may also remember when we talked about the Upjohn case, which the court ultimately said that the surveys that the lawyer did internally, the internal audit, was privileged, but the lawyer had asserted work product protection too. It was clearly work product, but he was worried that the feds would have a very strong, plausible claim of need and hardship, and so that's why they asserted attorney-client privilege in the alternative. And that concludes our lecture on the work product protection.